Hi, everyone, and welcome. I'm really glad you could join us today. My name is Jeffrey. I'm the General Manager at Cyberimpact. And I'd like to start by introducing the Office of the Privacy Commissioner of Canada, or the OPC in short. They're an agent of the Parliament, and their mission is to protect and promote the privacy rights of Canadians. And the OPC oversees compliance with two major laws. The first is the Privacy Act, which cover how federal government department handle personal information. And the second, and the focus of today, is PIPEDA, which stands for the Personal Information Protection and Electronic Document Act. This law applies to private sector businesses across most of Canada and governs how they collect, use, and disclose personal information. So if you're running a business, especially one that's new or growing, and you handle things like customer names, emails, or payment info, then PIPEDA really applies to you. Today's session, privacy on your business and your business, sorry, is a great opportunity to get familiar with the PIPEDA. Means in practice, you'll get an overview of its 10 core privacy principles, see how they apply in real world business situation, and you'll have the chance to ask questions at the end directly to our advisors today from the OPC. And for those who want a deeper dive, there's in-person privacy clinics also that are available after the session that you could directly, I think, book with the OPC there. So that's available as well. Sorry. With that said, before we start, I'd like to introduce our two speakers today. So we'll start with Charlotte Wong. Charlotte has worked at the OPC since 2015. She has taken a number of roles, including a Senior Privacy Investigator and Acting Director of the OPC Toronto Regional Office, and is currently a Senior Advisor in the Business Advisory Directorate. Charlotte's main role is to provide PIPEDA advice and guidance to organizations and ensure compliance with privacy law. She also conducts a variety of stakeholder activity and speaking engagement related to the PIPEDA compliance. Prior to joining the OPC, Charlotte held a variety of positions within the government of Canada and the private sectors, and she holds an international Bachelor of Business Administration degree from the Schulich School of Business. And Kelly Orn, with over 12 years of experience working with federal privacy legislation. Kelly joined the Office of the Privacy Commissioner of Canada, or the OPC, in 2020 as an advisor with the Business Advisory Directorate. For Kelly, talking about privacy has become a passion, which is good because I really like privacy. So
We have that in
with the
common.
with the OPC, Kelly works closely with individual business to provide practical, meaningful advice and guidance on their personal information handling practices. She enjoys working with businesses of all shapes and sizes through presentation, privacy clinics, and consultation to help them better comply with PIPEDA. And without further ado, I'm going to let Charlotte and Kelly start this webinar.
Thank you so much, Jeffrey. And little did I know, Jeffrey covered at least 3 of the slides that I was going to talk about. So this is great. He's like our third presenter. So I'm really excited about that. But thank you everyone so much for joining us. I've just added a note in the chat, just covering that you will have a copy of the presentation available to you after today. So don't worry about taking notes or writing down links or anything like that, because there's lots of good information. But there's a lot going to be covered in this presentation, and it's easier just to listen, ask questions as we go along. You can put them in the chat. We will do an actual Q&A session after the presentation. So any questions in the chat, we'll address those, as well as any questions if anyone dares to turn their camera on and wants to speak directly to us, you're more than welcome to do that as well. But either way works. So as already mentioned, we work for the Office of the Privacy Commissioner of Canada, and we're just here today to talk about PIPEDA, which is a law that affects any business in the commercial private sector that collects, uses, or discloses personal information. So today we're going to go through that law. What are the different principles? What are some of the big overarching themes that law covers and talks about? We're going to look at that law and practice through a couple of case studies that have to do with, generally speaking, some bad marketing practices. And then we're going to look at what services Charlotte and I have to offer through the OPC. If you have questions, if you want to talk to someone about how to better achieve PIPEDA compliance. And so the first one that, Jeffrey kindly covered for me, but that's great because this is kind of the background stuff, is, the who we are. So we are an agent of parliament. We do oversee the Privacy Act and the Personal Information Protection and Electronic Documents Act, which is PIPEDA. Small thing that we also do at the OPC is we do share some responsibility for enforcing certain provisions under CASL, which is the Canada anti-spam legislation. What we do there is we look at businesses who are harvesting emails, which you are not allowed to do. You're not allowed to mass collect emails, public scraping across the internet for the purpose of marketing. And we also look at the installation of malware or spyware by businesses onto browsers or devices. So if a business is tracking individuals on their device or on their browser through the use of spyware or malware, that's something that we would investigate on our end as well. It's important to note, though, that for the majority of CASL, most of the provisions are covered by the CRTC, and some are also covered by the Competition Bureau. So unfortunately, I don't have any good answers to deal with auto dial robots or anything like that. That would not be within our capacity. Generally speaking, and as we sort of covered in the very beginning, PIPEDA applies to any business that's operating in the commercial private sector within Canada. However, if you are a business that's operating in Canada, there's a couple other privacy or private health information laws that you should be aware of. First of all, if you're operating your business in Alberta, BC, or Quebec, those three provinces also have laws that pertain to personal information handling in the private sector. And so if you are operating in those spaces, you may also need to be compliant with those in addition to PIPEDA, or instead of PIPEDA if you're only operating in one of those three provinces. So just important to know where you're operating, where the personal information is being collected. Now, those three laws are what we call substantially similar to our own. And so what that means is they are very closely aligned with each other. So generally, if you're compliant with one, you're compliant with the others. But each one of those laws do have certain provisions that you do want to be aware of because there are a few differences. Sometimes it's about information traveling across borders. In Quebec, there's been some recent legislation in regards to language of information that might impact you as well. So while we don't offer consultation services on those sectors, what I would suggest is we have a great resource on our website that you can use to kind of filter out where am I doing business, which laws might apply, and you can kind of get a sense that way. But just to be aware that they exist. Also, if your business is handling health information, you may also need to consult provincially if you're operating in Ontario, New Brunswick, Nova Scotia, or Newfoundland and Labrador, because those provinces have specific legislation for businesses who handle health information. Okay, so you may have to be compliant with PIPEDA and perhaps one or two other laws, depending on where you're operating, depending on the type of information you're handling. We're still very much more aligned than some other places in the world where I know there's a lot of different privacy legislations at play. There we go. So what is PIPEDA? Okay. So PIPEDA is, we've talked about the law, what applies, and what businesses are impacted by it. Just in addition to the private sector and commercial activity. And so what that means is that if you are a nonprofit or a charity, registered charity, PIPEDA would not apply to you, just so that you are aware that is the distinction. So commercial activity means anything that would be considered for profit. We also oversee companies like banks and airlines, federal works, undertakings, or other businesses, and in the personal information of their employees. So for those businesses, the personal information of their employees also is subject to PIPEDA. And one of the things that a lot of people will sort of complain or note about privacy legislation, and I hear it a lot. I heard it last night at my daughter's baseball practice, is that, privacy presents this roadblock. It's keeping me from doing the things I want to do, expanding my business, growing economically. And the whole point of PIPEDA is not to create roadblocks. The point of privacy legislation in general across Canada is that we should be encouraging financial and economic growth, but that there needs to be a balance. So the way I encourage people to think about privacy is it's creating a guardrail. It's creating limits for which you can find pathways to success. And the reason those pathways are important is because everybody here, as much as we may be business owners or we may have our own business, we're also consumers of information. And so, for as much information that we're collecting as business owners, we're also doing business with a dozen other companies at the same time. And so, we want to encourage people to think about it through the lens of reasonableness, through the lens of appropriateness. And you're going to hear those terms a few times here. That is something that is ever shifting. So reasonable is not a static definition. Obviously, over time and throughout history, that what we expect as consumers changes and expands. If you asked people 25, 30 years ago whether we would have social media accounts, that we would be posting pictures of our children publicly online for consumption, I don't think that people would necessarily find that reasonable. But now it's that line has changed. Going and doing business online, giving people our financial information online to do credit card purchases through Amazon 35, 40 years ago would have been ridiculous. But now, again, our reasonable expectation has changed. And what is appropriate changes as well in sort of in connection with that. So we need to think about a balance between the right of privacy, but also that there is a need for businesses to grow and be financially successful. And we want to create the guardrails for businesses to do that. So before we get into the law itself, we like to just talk quickly about what is personal information. There's a lot of times where Charlotte and I will meet people at events and shows, and the I've heard this comment often, in Charlotte, just you can nod your head if you've heard this too. Email addresses aren't personal information. People don't care if you have your email address and I just keep it wherever. And we say to people is, well, what if that email address contains the person's first and last name? What if the ending of the email contains where they work or where they go to school? What if it contains, other information in there that, might make them identifiable? And so the reason why this definition is very broad is because it's meant to capture a large amount of information. So personal information is any information, factual, subjective, that whether it's recorded or not about an identifiable individual. If that email address, because it's connected to a person, if you have that email address and you can use that email address to connect to, well, now I can find their Facebook account. Now I can use it to find their LinkedIn account. Now I can use that email address to find their account through, like, if you can use that information and make that identifiable to an individual, it is personal information. So it could be personal information on its own. And I think if we were in a room and I asked everybody to give me an example of personal information, I'd probably hear the same things: name, address, phone number, date of birth, social insurance number. I could think of some ones off the top of my head. But we want to encourage businesses to think very broadly about the information they're collecting. Could this become identifiable? And if so, it's not that you can't collect it, it's not that you can't use it. It's that you have to think about how to protect it, how to handle it responsibly under the principles of PIPEDA, which we're going to go into. So some examples here are obvious. Other things like personal opinions. So if you have a recorded, or if somebody is aware of a personal opinion that you have about a customer that you've written down somewhere, that you've put in a document, that becomes personal information. Social status, even an intention to buy something. And that intention to buy something new is going to become a little bit more important when we talk about that in our case studies later on. There's a video that you can all watch. But I'm going to flip over to Charlotte now to talk a bit about appropriate purposes.
Thank you, Kelly. So Appropriate purposes, it's an overarching requirement found in PIPEDA section 5.3. And it states that an organization may collect, use, disclose personal information only for purposes that a reasonable person would consider appropriate in the circumstances. And this is a really important sort of statement because it is overarching and something organizations really take into consideration throughout sort of their course of business activities. We have 5 factors that the federal court has set out to help organizations evaluate whether a purpose is in compliance, whether it's appropriate. I won't go through all, but to name some, we're looking at the degree of sensitivity of personal information, whether the organization's purpose represents a legitimate need, a bona fide business interest, and of course, whether the loss of privacy is proportional to the benefits. So before I forget, we have great guidance on this, the link on this slide, which really flushes out in more details these 5 factors. So we encourage you to take a look. But on the opposite end, there are also what we consider no-go zones. So these are never appropriate for a business to be collecting, using, disclosing personal information. Again, there are a lot of more examples in the guidance, but for the interest of time, just a couple, publishing personal information with the intended purpose of charging individuals for the removal of that information. That's an absolute no-go zone. Don't be collecting information for that. And of course, when we're collecting, using, disclosing information that's likely to cause significant harm to an individual, that's illegal, against the law, really that leads to sort of that unethical, discriminatory treatment. So these are considered no-go zones. Don't engage because it would be really considered offside to PIPEDA. So here is just an overview of our 10 privacy principles. Of course, we'll be going through each one, with the first principle being accountability. So I like to call accountability an overarching principle because to be accountable is one of the principles of PIPEDA, but it's also to be accountable for all of the principles in PIPEDA. And how do we go about being accountable? Well, an organization can appoint someone to be responsible for that compliance, to protect all the information that's held by the organization. And to help organizations do this, we're going to be developing and implementing privacy policies and practices that should include a number of things like procedures for handling complaints, inquiries, and of course, staff training. Generally speaking, everyone from the top to bottom should be aware of an organization's policies. Now, going on with the accountability, but as it relates to third parties, here the principle recognizes, personal information may be transferred to third parties, so allowed in PIPEDA, and transferred to third parties in different jurisdictions for processing, also allowed under PIPEDA. But what this means is that it requires organizations to use contractual or other means to provide a comparable level of protection while the information is being processed by the third party. So if we take a deeper dive into what this comparable level of protection means, it means that the third-party processor must provide protection that can be compared to the level of protection the personal information would have received if it had not been transferred. So it doesn't mean that the protections have to be the same across the board, but it does mean that it should be generally equivalent. And other means used by an organization, this include non-contractual oversights. It can include auditing mechanisms that the organization can use. Our next principle, identifying purposes. This is, I think, a really important principle and exercise for organizations to engage in. Organizations have to identify and document specific purposes for collecting personal information before or at the time of collection. And we have to remember these purposes must be limited to what a reasonable person would expect under the circumstances. And again, important exercise, because identifying the purposes should help determine which specific information to collect. And then we avoid that overly broad collection. And of course, we need to obtain consent if a new purpose is identified. And this is a great segue into our next principle, consent. This is, a key element of PIPEDA. It is really a cornerstone. Under PIPEDA, organizations are required to obtain meaningful consent for the collection, use, and disclosure of personal information. And to make consent meaningful, people have to understand, of course, what they're consenting to. And it is only considered valid if it is reasonable to expect that individuals, your customers, will understand the nature, the purpose, and consequences of the collection, use, and disclosure of their personal information. And we look at a couple of elements to sort of, help us with that. We look at what is being collected. Again, the purposes for the collection, ensuring it's appropriate. Are we looking at any third-party disclosures that might need sort of that additional express consent? And of course, always looking at the risk of harm. For consent, it can be required for an explicitly specified and legitimate purpose. Again, always coming back to the appropriate purpose, and can be withdrawn at any time. And on the slide, before I forget, we have an excellent guidelines. It's one of our most popular ones, guidelines for obtaining meaningful consent. It really does sort of flush out, what it is to be obtaining that meaningful, valid consent. And we have two forms of consent in PIPEDA, express or implied. And to help organizations evaluate which appropriate form to use, we look at a couple of things. We're going to be looking at the sensitivity of personal information, reasonable expectations of the individual, and this, residual risk of harm. So generally speaking, if we're talking about high sensitivity of personal information like biometrics, the risk of harm is high, then we're going to be, wanting to use that higher level standard of care. We're going to be asking for express consent. Consent, be innovative and creative, where you can look at just-in-time notices, making it more and more interactive experience. Always consider the customer's perspective, make sure it's dynamic and ongoing process. And there are limited exceptions to consent requirements in PIPEDA, where organizations don't have to obtain consent. But again, because consent is, at the heart, it's what gives individuals control of their own information. We apply these exceptions restrictively and quite narrowly. So all this information, again, on our consent guidelines really takes a deeper dive. So I really encourage you to take a look. All right, next principle, limiting collection. It's fairly simple, this idea of collecting only what is necessary to fulfill a business's identified purpose. And of course, we're going to be collecting that information by fair and lawful means. So we're not going to be deceiving individuals as to why we're collecting their information. Continuing on with the theme of this limiting principle, we have limiting use, disclosure, and retention. Again, it's sort of fairly self-explanatory. Personal information can only be used, disclosed for the identified purposes. That's why it's being collected, and only retained for as long as necessary. I think retention is a very important aspect of this. Don't keep information unduly long. If you don't need it, just sort of, make it anonymous, erase it. And to help with putting this all together, organizations really should be developing and implementing retention schedules and disposal guidelines and procedures. And our last principle, pretty self-explanatory, accuracy. This is important, making sure the information within your control, within the organization's control is, it's accurate, it's complete, up to date as possible. And this is important because that will minimize the possibility of using incorrect information. So this sort of completes our principles, and Kelly will.
Well, it doesn't complete our
Well, no.
principles. It completes the principles you're talking about.
All right.
We have more. There's more to go. The next one is one of the ones I think we hear a lot about. Consent, we tend to hear a lot about because it's such a large part of PIPEDA, and it sort of separates us from some other privacy legislations around the world. But the other one that a lot of people think about is safeguards, and that is protecting the personal information against either unauthorized access, against theft, against misuse internally. And so when we think about safeguards, we want business to think, first of all, how sensitive is the information in my possession? Am I just collecting names and email addresses? Am I collecting financial information? Am I collecting health information? Am I collecting information that if it were to be breached, or if it were to pass into the wrong hands, worst case scenario, what is the risk to my consumers? How much risk am I creating here? If you're collecting lots and lots of personal information that and altogether becomes sensitive, then you have to make sure that you're putting in robust safeguards to protect that information. So safeguards are thought of in three categories. So we have the physical safeguards. That is, if you're still doing pen and paper, there's not many of you left, but if you're still keeping paper records, they're going into secured locked drawers, limited access, only certain people have the key. If you're working in an office building, it's having access cards to the building. If you're transporting materials that are highly sensitive, making sure that you're not leaving things in your car or taking them on the bus with you. So those are your physical safeguards. The organizational ones, actually, I'll skip that one for a second because that's one I think sometimes we forget about. Technological is the one I hear the most about these days. So this is your firewalls, this is your encryptions, and these big fancy buzzwords. There's lots of people out there providing or selling, electronic safeguarding measures. And so that's your technological safeguard. So if you're doing things online, that's what you're looking at. The organizational ones are the ones that sometimes aren't as obvious. And this is your staff training. This is your having limited access controls in place so that only certain people, you have procedures in place so that when someone leaves an organization, that you've gone through proper offboarding of making sure they have submitted all their keys, making sure that they don't have access to personal information any longer. It's part of your staff training when you're doing your onboarding. So all training of staff should be done on personal information during the onboarding process, not 6 months in, not a year in. Okay, now you've been here a year, you'll do the training on personal information handling. That should be part of the initial process. So it's having the procedures in place and the structure within your business that you are able to control and limit access to personal information only to people who need access. It's what we call a lot of times that need to know principle. And that's probably one of the types of safeguards that's going to prevent a lot of issues right from the start. Because we don't have time to go through all the case studies, but if you ever have a chance to look up the Desjardins case that happened a few years ago, that's an example of when you don't have organizational safeguards in place and internally staff can access information they shouldn't be able to access. So those are the three categories of safeguards. And despite our best efforts, we know that breaches are going to happen. Not to everybody, not necessarily, but they do happen. We have entire teams that handle those breach reports all the time. What everybody should know here is, first of all, what constitutes a breach, right? So a breach it could be loss, it could be unauthorized access or unauthorized disclosure. So that's everything from I've lost a document that has a lot of personal information on it, a USB key, a hard drive has been lost accidentally. It could be anything from I've mailed the wrong documents to the wrong person by accident. And then it goes all the way up to someone has hacked into my system and taken all my files, which is kind of your extreme. That's sort of the worst case scenario, I think, for a lot of people. But breaches cover all of those possible scenarios. So what you should know is that within PIPEDA, you are required as a business to report a breach to our office if that breach involves the personal information that you possess, so it's something that you collected that you are the owner of, and if there's something called a real risk of significant harm. Now, that's a statement that doesn't necessarily provide much definition. So what we've actually recently done at the OPZ is we've just launched a tool, an online tool that you can go in and use, that if you have a breach at your business, you can go through, answer a series of questions. No information is collected. It's just for your own information. And you can say, what kind of personal information was impacted? How many people were affected? Who do you know what happened basically? Was this an external attack? Was this an internal access? Were you able to get the information back? Do you know where it is? So you'll go through a series of questions. And at the end of that assessment, you get a score. And that score will tell you if that real risk of significant harm exists. On a very baseline level, it's just a risk that, again, if worst case scenario, that information got into the wrong hands, where is the risk? Is it identity theft that could be at risk? Is it someone's physical safety that could be at risk? Is it reputational loss? Employment loss could be a risk. So it goes through different types of risks and tells you this is where the risk is high, this is where the risk is low. So it's a really, really interesting tool. I hope you never have to use it, but if you ever do have a breach, it is a great resource to use. And again, no information is collected by our office by using the tool. We're not gathering anything. It is simply for your own information. And you'll get instructions after that on what to do, how to report, how to go through those steps. And then, of course, there is a risk of fines or penalties if a business knows that they've had a breach that they should have reported and did not report that breach. So if it comes to our attention through a complaint down the road and we find out that you were aware of it and chose not to report, you do run the risk of facing additional fines. Okay, so openness is just about your policies. I don't know, and this is a great question for the group here, who has a privacy policy right now for their business? We're noticing overall, because we do a survey of Canadian businesses every year, we've noticed that there seems to have been fewer and fewer businesses that are developing a privacy policy. Now, that could be because they're obtaining consent in different ways. I don't know. But you should have your policies and practices available to your customers. So there should be some way that your customers are able to understand what you're doing with their personal information, who has access. It's written in language that's not at, the top academic college level reading levels. It should be written in a language that is appropriate to what you would expect your clients to be able to understand. So if you don't have a privacy policy, or you're working on one, that's fine. What Charlotte and I actually do, and we'll talk about this after, is we do reviews of privacy policies once they've been developed, and we can give feedback on those. But it's something that you want to have something in place, whether it's an open privacy policy or something available that your customers can readily access and understand, so that they can understand what you're doing with their personal information. The last two principles, and they really are the last two, have to do with rights that the individual has. So first, there is the right to access. If you get a request from a client or customer asking for a copy of their personal information that you have in your possession, they have the right to receive that information at little to no cost. If there is a cost, there has to be a very good reason for it, and that response should be given within 30 days. That's your obligation as an organization, as a business. They have the right to request their personal information, and they have the right to challenge the accuracy if it's wrong. So if they get a copy of the information and they are saying, that's not my information or that's not right, you have to review that and see if changes need to be made to their information. And the last one has to do with complaints. Again, if a customer or client is not happy with how their information has been handled, they can contact you. We will encourage them to contact you actually first, as a first contact in the event of a complaint, to see if it can be handled internally. So if a customer comes to you and says, why did you give my information to XYZ? Or I don't like that my information you collected this information. I don't think you need to have it. You have to review it. You have to provide a response. And if improvements are required, if you have to make changes, then those are changes you need to implement. If after the end of a complaint, the customer still isn't satisfied, then they would come potentially to our office to file a formal complaint. We always encourage customers to try to resolve these things internally where possible, but just so we know, that's the process. So you should have a procedure in place for handling those complaints. So those are the 10 principles now within PIPEDA. And as we were going through, I hope everyone was kind of thinking, am I doing these things? Do I have procedures for all these things? Are there maybe things that we haven't thought about yet that we're still, maybe we need to be thinking about? So I'm hoping that as we go across here, that you're seeing, okay, we have this in place, we have this in place, we have this in place. But if you don't, that's fine. This is sort of an opportunity for you to go back and reflect on those. And now we're going to talk about putting those principles, some of those principles into practice. We have a couple of case studies. Charlotte has the first one against nasty Home Depot. I'm going to let her talk about that.
Thanks so much, Kelly. So some of you may have been aware of this investigation our office did from Home Depot. It really started when a complainant came to us, and while he was deleting his Facebook account, he learned that Meta had a record of most of his in-store purchases that he made at a Home Depot. And this really all started with the option of receiving an electronic receipt, right? So when you're asking for, to be sent an e-receipt, you're going to be inputting your email address. So what this investigation found was that Home Depot then forwarded this particular customer's email address. It was hashed, it was encoded, but nonetheless forwarded that email address and sort of offline purchase details to Meta, and it was done through a tool called offline conversions. And then what subsequently happened was that Meta would match the email address to this customer's Facebook account, of course, when possible, and then proceed to compare those offline purchase information to ads delivered to the customer on Facebook, ultimately to make sure that those ads were effective. So, of course, at no point in this entire process, from asking the e-receipt, were customers advised that Home Depot was sharing all of this information, offline purchase details, with Meta. And we learned that this practice had been in effect since 2018, so it was not something new, not something recent. So what sort of the main principle that really had come to light with this particular investigation was, again, this notion of consent. Remember, again, consent, cornerstone of PIPEDA, really important. So, ultimately, Home Depot disclosed customer personal information to Meta and contractually authorized Meta to use that information both on behalf of Home Depot and for Meta's own business purposes. So we really have sort of two streams going on here, one for Home Depot and one for Meta's own business purposes. Again, customers not aware of this did not, really give that consent. In their response, Home Depot said, they obtained implied consent through their privacy policy. And also in their view, the information collected, sort of these, offline purchase details, it was non-sensitive. Okay, a person bought a shovel, a tarp, a tool, not sensitive, and therefore could get that consent implied. Again, you could read it through your privacy policy. Reasonably expect that this type of sharing, to Meta was absolutely okay. Another sort of point that Home Depot gave us was that they referenced consent fatigue as a rationale for why, at the time the customers requested e-receipts, it did not notify customers at that point of time of its practices vis-a-vis sharing sort of all of this information with Meta. So ultimately, we've got a couple of findings here. And, key topics, very interesting. In the specific circumstances of this case, though the personal information collected singularly may not have been sensitive, we are talking, and Kelly did mention this earlier, we are talking about offline purchases and spending patterns that I think can really portray an individual. Just for example, it doesn't have to be with Home Depot, but a person buying baby items at one point in their time, specific types of medication in other points of time. It really could paint a picture of that individual. Can be highly sensitive at times too. So again, when it comes to sensitive information, we really have to be careful. We really have to look at those risks. And these circumstances, there could have been, a high risk in sort of other retail contexts. And so there's another point, importantly, when requesting that e-receipt in store, ostensibly customers would not have reasonably expected that by giving their email address to get the e-receipt, all of this background information would have happened, that their offline purchase details would have been shared with Meta to use for their own business purposes, to make sure that the ads were sort of relevant on Facebook. And no, customers would not have, again, at the time of requesting the e-receipt, looked up sort of Home Depot's privacy policies, which could have been lengthy, buried somewhere in there, that this whole process was going on. So in conclusion for all this, Home Depot really should have been obtaining that express consent, really going for that higher level of care, since the collection, use, and disclosure of personal information really fell outside the reasonable expectations of that individual, again, when asking for that e-receipt by giving their email address. Just to sort of go on with this idea of valid and meaningful consent, Home Depot did not proactively advise customers that this disclosure was happening, placed that heavy emphasis and burden on the customer to go looking for the information again in sort of this lengthy privacy policy. It really meant that consent could not be considered valid or meaningful. So interesting report of findings. Obviously, take a read when you do have time. Sort of a couple of learnings. Home Depot has stopped this practice, with our recommendations. We've also highlighted that should Home Depot want to sort of re-implement this practice, really be transparent in the messaging to sort of your customers. Make sure they think things through. And Home Depot did say that they would take our recommendations into consideration. And our next case study, Kelly.
Nasty Tim Hortons. I am looking at the time. I do know that I would like to have a few minutes just to cover some questions. I know we started a couple minutes late, so we're happy to stay a little bit later if necessary. But I just wanted to point that out. I'm going to go a little faster through this one because this is one that you may have read about. But essentially, what happened in June 2020 is a reporter published an article in the National Post. And it talked about his sort of experience of he had the Tim Hortons app. He was, he had done he had noticed some strange notifications on his phone. Tim's is tracking your location at all times. And he goes, what's this? So he starts digging into it. He doesn't access to information. He has an access request with RBI, which is the organization that owns Tim Hortons. And he gets this giant report. Well, Tim Hortons apparently had been tracking him over 2,700 times over the period of 5 months. And so he's looking, and they're tracking him, tracking him when he goes out of the country where there aren't even Tim Hortons located. They figured out where his home office was. They figured out where his house was, his work office was based on frequency of visits. And they all were also tracking when he was visiting a competitor. So if he goes into a Starbucks, there was a record of that as well. So why was Tim Hortons doing all this? What was the point of all this? Essentially, Tim Hortons had started a marketing or planned marketing scheme with this third-party organization called Radar. And so they were using the app to continually track people's location with the intent of using it for targeted advertising. So when you step into a competitor's location, you get a notification from Tim Hortons. They never actually got to the point of launching this. So they collected about over a year's worth of information from April 2019 to the end of September 2020, they were collecting all this. So they had thousands and thousands and thousands of records on people and their locations, although they had no legitimate need to do that because it's they weren't actually doing anything with it at the time. So ultimately, that was how the investigation got started, was through a National Post article. So sometimes people ask what triggers an investigation. Sometimes it's a complaint, but sometimes it's things that happen in the media as well that we become aware of. So the at play here are in terms of principles, we have first of all, the appropriate purpose that Charlotte talked about earlier. There was no legitimate need to collect all this information. It constituted surveillance. The loss of privacy was not proportional to the benefits that would have been obtained. So for the purpose simply of targeted advertising, there's no need to collect continuously that much personal location information. Consent was not, there was no valid consent. No one was ever told. In fact, there was deceptive advertising at times of this because you get that option of it's tracking you when you access the app. And so people believed when they accessed the app that that's the only time that their location was being tracked. But in reality, it was being tracked 24/7. So there was no valid consent obtained. The privacy policies that were released did not cover this, did not clearly explain it, did not really explain Radar's involvement in this. And so there's no way, even if somebody said that they consented, that they would actually understand what was happening with that app. Ultimately, there was also issues between that. We talked about that contractual obligation between a third-party organization. And because Tim Hortons had already stopped the activity at that point and had committed to deleting all the information, the OPC didn't have the resources to really dig into this, but there were some parts of that agreement that were also very suspicious, that didn't show that Radar was protecting that information, the same as if Tim Hortons had maintained control of that location information. So these were two sort of concepts that didn't go through a thorough investigation because Tim Hortons had already stopped. So ultimately, we addressed the issue, and that had stopped happening. But there were some other principles at play here that if we wanted to do more of an investigation, we could have. It wouldn't have changed the result overall. And the consequences of some of this, in case you had the app during that period like I did, was that there was a 2022 class action lawsuit. You may remember that you were at some point offered a free hot beverage and baked good as a result of this investigation. That was the settlement that was agreed upon by Tim Hortons. I'm going to tell you that some people did the math, and if every single person claimed that hot beverage and baked good at the maximum value, it was about $16 million in cost for Tim Hortons. And you might think that that's a lot, but RBI, which is the owner of Tim Hortons, had net sales of over $2.08 billion last year. So they're making about $40 million a week. So when you put the numbers together, that settlement, I know there was a lot of complaints about it, but it's indicative, at least symbolic, of the fact that there was a consequence that came out of this for Tim Hortons that they did have to ultimately pay. So whether it's a penalty or fine imposed by us, or it can sometimes be penalties that are sort of imposed after the fact. So the reputational harm, the class action lawsuits that can generate as a result, those sometimes have bigger impacts than just the investigation itself. So how do you not become a Tim Hortons or a Home Depot? One of the things you can do, as mentioned, as I know Jeffrey mentioned at the beginning, is talking to us. So if anyone after today's presentation is interested in having a further discussion specific to their business, we do have consultations that are available. And that's just one-on-one, confidential. We talk about your questions, concerns, where the business is going. We give very, very specific and meaningful advice. Privacy clinics are a shorter version of that. That's about an hour-long meeting. I'm not necessarily going to have time to review a privacy policy in that time frame, but we can talk about certain sort of high-level things. If you're just in development, or if you just have a very simple one-off question, that might be a better fit just to having a one-on-one conversation in the shorter time span, as opposed to a full-blown consultation where we're looking at everything. But some of the other things that we offer, we do these types of speaking engagements. We do exhibits, which is where we met Jeffrey, at DX3. And so we're out there doing outreach as well, trying to keep people aware of these obligations. So whether you speak to us or not, if you leave today's presentation with a little bit of a better understanding of the law and how it applies, and if you're going back to the table and thinking about how you might apply some of this information, I think that's what we consider the success of today. So you're always welcome to ask questions and speak to us. But if you just want to look at the website, gather your own resources, and take some time to reflect, for us, that's equally as important. Because the idea is if we develop this sort of privacy by design culture into our businesses, we're going to put ourselves on a better footing to be able to make customers feel safer with giving us their personal information. And we're going to feel safer. And as business owners, we feel safer then as people who are able to say with confidence, your information is secure, we have solid procedures in place. We're going to avoid those complaints and potentially other issues down the road. So I do want to just maybe skip ahead. We have some resources that we'll go through at the end that'll be a part of, you'll get a copy of the webinar. So you'll be able to go through all of those and have a look. But let's see if there's any questions.
There are a few questions, so maybe we could go. I took them all in notes there. Dan was asking initially, what's your position on ZoomInfo, Apollo.io, Outreach.io, all those systems that are gathering personal information? Like, is there like a specific position regarding that? Can we use it? Like, is it legal?
There isn't an official position against a specific organization because we've looked specifically at them, and we don't work in investigations, but still, I don't believe there's any active investigations that I'm aware of for a specific company, and without seeing their practices and talking to them, there's not an official position we could give. What I will say is the OPC does have some resources contained within about data scraping, about our role in terms of email harvesting. So there are general resources about those activities that if that applies to a particular business, that's something that if somebody wants to bring that to the OPC's attention, we are a small department. We cannot investigate necessarily every business in Canada, but it helps if you're noticing something and you're noticing a practice that you find suspicious, bringing that to the attention of our compliance team.
All
And
right,
then we
thank
could sort
you.
of take a look.
Alexa was asking, interesting. She was mentioning interesting that if we are a nonprofit organization, PIPEDA does not apply. Are there any other privacy laws act we should be aware of?
So I'll take this. I think I wouldn't be familiar with sort of these other privacy laws or acts particular to sort of nonprofits. But what we always do tell nonprofits is that you can use PIPEDA as a benchmark, right? You can apply that sort of same thinking and sort of that privacy by design for nonprofits. I think being accountable, being transparent with your customers, safeguarding and treating the information appropriately, whether that's PIPEDA or that's another law or act, I think it's a good benchmark for organizations to use.
All right, thank you. Amy was asking, we are a government run recreation facility that uses third-party software to collect an individual's information and register them for our program. I understand that we have implied consent to email patrons who are currently registering a course, but are we following PIPEDA legislation on consent if we send an e-newsletter out to all emails contained in our system? I mean, what she was saying at the end is, as long as we're providing them the option to unsubscribe, are they okay with it there?
Yeah, there's a couple of interesting words in there that are giving me pause. One is government run. So I do question whether PIPEDA would even apply to a recreation facility. Typically, those are governed by that government, whether it's municipal, and I'm guessing municipal in this case. And so municipal entities, provincial entities, they have because it's not technically considered commercial, it's considered a part of the municipality or province. those have their own procedures and policies. So the third-party software company, because they are a commercial company, they would have to be compliant with PIPEDA. And so you've got a little bit of both going on their end. I would say that there is, okay, so if it's for, we're currently registered for a course. So this is just specific to marketing. PIPEDA does have a resource on marketing and what you can and can't do. Generally speaking, if a person has given you their email address related to a course that they're looking to take, or you're sending them marketing for other courses, that's typically a part of the privacy policy and generally falls within most reasonable expectations. Having the unsubscribe option is very good so that people can take themselves off that mailing list if they want. So I think you're probably going to be okay there, but because you are a government facility, you're probably not fully subject to PIPEDA anyway, is kind of where I would sit with that. So there might be some differences in your procedures, but I don't
Yeah.
see any big red flags here as
Maybe-
long as you have the unsubscribe.
Maybe just a quick reminder that unsubscribing from a mailing list is not the same thing as removing all your information from a
Yeah.
database there.
Yeah.
So that's two separate things. So if a person wants to make sure that they're removed completely from a company, they should be like doing a
Delete.
separate demand for that.
Yeah, there should be a separate request for account deletion versus a mailing list.
Yeah. Wendy's asking, what if you're an independent contractor working within another business and that business is not always following privacy protocols? I guess
Oh,
that answers the
Yeah.
question right away there. So
Yeah.
third-party accountability.
Yeah.
I'm sure that just instantly came about. You know, we want to, again, that comparable level of protection. We want to make sure that, you know, they have the appropriate safeguards in place, just like your organization would. You know, making sure that they're treating the personal information appropriately under PIPEDA. And again, how we're going to do this is through those contractual obligations, right? In a contract, sort of spelling out what is going to be that appropriate sort of processing, or how we're going to be appropriately treating that personal information. So at this point, you know, if they're sort of offside, that can be a problem.
thank you. Cindy's asking, can you confirm the length of time client files should be kept if you haven't seen client for years, as an example?
We get this a lot. So PIPEDA is not going to give you, this is the length of time. We don't have a prescribed length of time. The way you do it is this. I'm collecting this person's information for what purpose? Why am I collecting this? To provide a product, to provide an ongoing service, to provide a one-time service? You know, what is the purpose that I'm collecting that information? Reasonably, how long do I need to hang on to that? Marketing wise, think about accuracy after 2 years, 3 years. If you haven't heard from this person, is it likely that they've received their service or product and they're no longer looking for additional service or product? Then that should be a point in which we set up after 5 years, we start deleting. After 3 years, we start deleting. Each business has to think about it individually because the sensitivity of the information, the longer you hold on to it, if it gets breached, the more risk you run for yourselves. So think about the purpose why you collected it. Have you fulfilled that purpose? Reasonably, if you don't need to keep it for any longer than that, then you should be setting up a schedule, as I think Charlotte had mentioned, that every 5 years, if we haven't heard from you, it's the account is dead, it's inactive, whatever you want to call it, and we start to delete those. If the person comes back 10 years down the road, you can explain to them, you know, we hadn't heard from you. We have a retention schedule. This is what we've done. And they'll just enter their system as a new customer. Might be a little more work for them, but it's reasonable. I don't think it's reasonable for people to assume you're going to hold on to their information forever. So set up that schedule and just start every 5 years, every 3 years, whatever it is, just start deleting in accordance with that. And it's going to make your life a lot easier too.
Yeah, it's a best practice to implement
Yeah.
that.
Yeah.
We got 2 more questions. So there's what rules apply to charitable institution? I think it goes with nonprofit or
Yes, exactly.
Yeah.
So at this time, PIPEDA at the very least does not apply to non-for-profits and charitable institutions. But as you know, we mentioned, you can use us as a benchmark. You know, we're all of these same principles. It's only a good practice.
Yeah.
Someone's asking, does the Privacy Commission work with companies like MailChimp, Constant Contact, and Hootsuite?
Not that I'm aware of. If we're talking about federal departments in general, there's a specific procurement process. If you want to work with a third-party organization, there's a list of approved vendors that have been vetted and analyzed and have been deemed appropriate. We don't work with anyone outside of that in any official capacities. So those names don't look familiar to me, but you can always find out if they're on that list by going and checking with Procurement Assisted Canada.
All right, sounds good. I had one question myself that I'm just wondering, is there like any position or anything that you have to say on the use of ChatGPT, especially people that are using like personal information just to put in ChatGPT to get other comparison or anything like that? Is there something that we should be aware of?
So I don't know how many people here are aware. The commissioner announced some time ago, and I don't remember the date off the top of my head, but he announced it, that there is currently an investigation with concerning OpenAI and ChatGPT. Until the results of that investigation are posted, you won't have an official position on the use of those tools, but just know that that exists, that investigation is ongoing. I do expect it'll probably reach a conclusion in the near future. So I would say to everyone, keep an eye on our website because it will be officially posted there, the result of that investigation, and then we'll have some more detail. And we're constantly working on guidance related to, there is some guidance that already exists with relation to the use of AI, maybe not specifically Gen AI, but we do have some things for businesses to think about when they are using AI tools.
All right, thank you. We've talked about that us three before the webinar, but I'm always telling our client that it depends where you are doing business. So it's not, in Quebec, we think that only the law 25 prevails on everything that we're doing, but really depends on where you're doing business across Canada. And that's the reason why we did this webinar.
Exactly.
PIPEDA is that actually applying to, any company that is doing business in the provinces mentioned, and Alberta and British Columbia as well, different there. So
and even if your information is crossing a border, whether it's a provincial border or an international border, so if you're transferring information internationally or across borders, even if you're only operating in Quebec, you may still have to be PIPEDA compliant in that case, because if the personal information leaves Quebec in any way, then PIPEDA would also apply.
Well, thank you very much, Charlotte, Kelly, for your time, for all the information that you provided. We will definitely send the PowerPoint and give as much information as we can to everyone that registered for the webinar and to all our clients. So you might get busy in the upcoming weeks with a lot of demands there.
That's okay.
We're looking forward to it.
Sounds good. Well, thank you very much again for your time and everything.